Hi, everyone. We're going to go ahead and get started. Today's Chatting with Charlie is navigating Charlie's predictions for fiscal year 2024 and the impact on the company green card programs and how companies can be strategically prepared. We can go to the next slide. So just, of course, our legal disclaimer, this does not constitute legal advice, informational purposes only. Of course, if you'd love to get any consultations or opinions, please schedule consultation with one of our attorneys, and our information is there. I'm Charina Garcia. It's nice to be back. I've been away for a couple of months. I want to thank Laura for moderating the panel and the Chatting with Charlie while I was away. I practice in the Northern California area. I'm a partner with WR Immigration, and I've been practicing for over 26 years. And Charlie Oppenheim is the guest of this Chatting with Charlie. And it's very funny because I was looking back at my career, and when I started practicing back in 97, 98, and that's roughly around the time Charlie became the director or the chief of the Immigrant Visa Control and Reporting Division. So Charlie is with WR Immigration's team and heads up our government relations group, and he's our director of visa consulting. Like I said, his career with Department of State spanned 43 years, with his last position as the chief of the Immigrant Visa Control Reporting Division, which was from January 98 to December 2021. His main role was to oversee the allocation of immigrant visa or green cards, which resulted in 9 million immigrant visa issues. He's also known as the man behind the black curtain, or what we also like to call the Wizard of Oz. So Charlie, welcome to Chatting with Charlie.
Thank you.
And we also have Laura. Laura, why don't you go ahead and introduce yourself?
Hi, everyone. I'm Laura Bloniarz. I'm a senior associate with WR Immigration in our Santa Monica office, and I specialize in business immigration, which means I'm helping companies develop, maintain, and defend their corporate immigration programs.
Thanks, Laura. So our next slide just talks about our firm a little bit and our mission statement, which is to journey forward with our clients. We have 9 offices globally and over 200 professionals and growing. We'd love it if you'd reach out to us, and we'd love to share our mission, our values, and our technology that we have developed using Salesforce. All right, so today, what are we going to talk about? So we're going to talk about the numerical control process, again, about the Visa Bulletin and the visa availability, what to expect in fiscal year 2024. Laura and I will talk about corporate green card policy benchmarking and some best practices for your green card program. So with that, let's talk about the employment-based green card process. So Laura, can you walk us through the typical green card process for those being sponsored by their employers?
Yeah, absolutely. So generally speaking, an employee who is being sponsored by their company is going to go through this process. First, they're going to go through what's known as the labor certification, also known as a labor market test. And this process is administered by the Department of Labor. The Department of Labor has a very specific rule and process on how a company is required to test the U.S. labor market. And we can have a whole session just about all the rules and timing related to that. But suffice to say, it's taking quite a long time to clear the labor certification process through the Department of Labor, largely because the Department of Labor has such backlogs in issuing prevailing wage determinations, which is a required step before filing the labor certification application, known as the PERM application, which is taking then another year to have certified by the Department of Labor. In any event, once that's approved, that foreign national can then proceed with the immigrant petition, again, through the sponsorship of their employer. to file an immigrant petition with U.S. Citizen Immigration Service. Once the immigrant petition has been approved, the foreign national is given a priority date, which the analogy we like to use is like a ticket in line, you're at the deli, you pull the ticket, and that's your number in line. And the visa bulletin is the scheduling mechanism, or the stoplight, so to speak, for the advancement of when the foreign national is eligible to submit the adjustment of status application. So that's generally the path that an employee is going to follow. There are some special cases where if both the foreign national and the employer qualify, they can skip the labor certification step. So this is often the EB1 category or a national interest waiver. So some special categories can skip the labor certification and file directly with immigrant petition, but all foreign nationals are subject to the visa bulletin scheduling, essentially.
And for the labor cert, you said it's a long processing time. So what are you seeing right now in terms of processing time for labor certs?
I mean, all in, it's probably going to take a foreign national about 2 years to get the labor certification. There are some ways to have some shortcuts if the program you're involved in or the employer can sponsor a batch perm and cut out some of the wait time for the prevailing wage request. But the majority of folks have to go through the process sequentially, meaning they have to secure the prevailing wage request, and then they can complete the recruitment. And again, there are some ways to sort of shave some months off of that, but largely anchoring to 18 to 24 months to receive a certified application is about right. And again, largely that is just the processing time with Department of Labor.
Yeah, and if companies have gone through any sort of reduction in force, that's also going to impact and delay the filing of the labor certification, right, Laura?
Absolutely. So even the 2 years is kind of the best case scenario, meaning that there's no undue delay because of any reduction in force or things like that that could dramatically delay. And when I say dramatically, like at least 6 months. So that's a pretty substantial amount of time from the overall processing.
Okay, thank you,
Definitely.
Laura. Yeah.
Excellent.
So, Charlie, let's talk about the visa bulletin. Can you describe it and explain to us what the visa bulletin is?
Sure. The monthly visa bulletin is intended to provide the public with information on visa availability for the upcoming month, which applicants will be eligible for an interview overseas or visa processing in the U.S. And it also provides other visa-related information. For example, if the State Department were aware that there could be retrogressions or rapid advancement of dates in the coming months, they would put that information in the visa bulletin. But most of our listeners, you probably have some type of household budget, and you do that, establish that budget based on your estimated expenses versus your income. And you may look at that on a monthly basis or throughout at various points in the year to see if you may have more or less money to spend on items. So the State Department does pretty much the same thing. There are annual limits on how many numbers can be used in both the family and employment category. So the State Department establishes a target of how many numbers they want to use on a monthly basis. So by the end of September, they will have maximized number use under the various annual limits. So the advance or the movement of the dates on a monthly basis is intended to use that amount of numbers. So beginning in roughly November or December, the State Department would look at actual number use in earlier months versus their target for number use in those months. And then the upcoming month's dates would be established based on whether they need to slow the number use, they need to hold the number use at their targeted level is good, so they want to use the same amount the next month, or they may need to increase it. Maybe their target was to use 1,000 numbers, say, for the month of October, and they only used 500. That would mean they need to move the final action date at a faster pace. Or if they get near the end of the year, they may find that they're running out of numbers, so they either have to hold, or potentially in a worst case situation, retrogress numbers to hold number use at the end of the year within the annual limit. So again, view the Visa Bulletin, the dates is kind of like your household budget.
So for example, if I have my household budget, but then a storm hits and then something happens to my roof or there's a leak, then I have to, and I wasn't prepared for that, then that means that I have to hold my budget at a certain place and not be able to spend for some time. Is that kind of the rough idea?
Then you may not be able to go on that elaborate vacation you had planned. You may have to have a staycation, or you may have made estimates on, you were going to have household repairs, and you get toward the end of the year and you say, nope, haven't had any household repairs. My utility bills have been lower. I can go on that extra extravagant vacation this year. So again, if you look at the dates, they're kind of like you're making adjustments to your budget throughout the year.
Thanks, Charlie. That helps really understand how the numbers are used in a more simplistic term. So we can move to the next slide. And we just wanted to put this slide out there because Laura talked about the place in line, your priority date, and the deli ticket number. And I think you're after me, and look at that number, it's 86,537. And I feel like sometimes people really feel like that's just really how long it's taking. Like there's just so many other people ahead of you in line, and when are they ever going to call your number? We can go to the next slide.
Well, and I think there's a lot of comparison, right? So how the lines are moving, and anyway, yeah.
I know, like sometimes it's faster, it's more efficient. Like you said, there's more numbers out there, so the lines are actually moving faster. So I always am a positive person. I always think that, I've been doing this for 26 years, and I've told people many times how long I think it'll take, and I'm pleasantly surprised that it's actually less time. So I always say don't despair, even despite everything going on right now with what the visa allocation numbers look like. This is just kind of a visual for everyone about how the visa numbers can flow up and down based on the employment-based categories. And so Charlie's going to talk about this next chart, which walks you through the immigrant visa numerical allocation. So Charlie, can you kind of tell us what this chart is about and how this works?
Sure. Each of the employment categories gets a certain percentage of the overall employment annual limit. The EB1, 2, and 3 get 28.6% of the annual limit, and 4th and 5th get 7.1. So the EB1 limit, if there's not enough demand to use all of those numbers, any extra numbers can then fall down and be used in the second preference category. And then if there's still unused numbers in second, they can fall down to the third. There is no fall down into 4th and 5th, but if there are unused 4th or 5th preference numbers, those numbers can fall up to use in the employment first preference. This was a very beneficial process in earlier years where there was not as much demand in EB4 and EB5, and there would be thousands of unused numbers in those two categories that would get added to the overall employment first preference limit. That allowed the India and China dates to either stay current in many years or advance at a more rapid pace. Unfortunately, in recent years, the number use in the 4th and 5th preference has been maximized, so there really hasn't been any available numbers to fall up to EB1, and I don't foresee that happening in the future. So again, this is kind of as the previous slide shows, the water trickles down and then it can flow back up to the top and start the cycle over again.
But you're not thinking that we're going to have more extra numbers from EB4 or EB5?
No, EB4 and 5. In EB4, the number use is all being used now, primarily because so many numbers are being used for juvenile court dependent cases. That is using up all of the available numbers. And in the EB5 category, there was a an act, the Act of 2022 established some reserved categories, so it divvied up the pool of numbers in EB5 more, and so I don't believe there'll be any unused there either.
Okay, so we can move to the next slide, and these are the employment-based annual limits. So starting with fiscal year 2019, which is basically October of 2018, and running through fiscal year 2024. And Charlie, the asterisk by fiscal year 2024, what does that mean?
That is an estimate. Right now, I would not be surprised if in the December Visa Bulletin, if the State Department announces what the actual employment limit will be for 2024. So look in paragraph number 2 of the bulletin, or in the notes at the back of the bulletin, to see if they provide what the limit will be. But for illustrative purposes, we've used 160,000. What that reflects is there were approximately 20,000 or 25,000 roughly unused family numbers. Any unused family numbers from fiscal 2023 get added to the employment minimum limit of 140,000. So we have a nice 160,000 estimated limit this year.
Okay, but if we go to the next chart, we can see the surges, right? Where they're actually more in fiscal year 2021 and fiscal year 2022. And the explanation for that, of course, is COVID, right, Charlie?
Yes, the State Department uses approximately 95% of the family-sponsored numbers. And during the COVID times, most of the overseas embassies were shut down and had minimal processing. So there were excessive amounts of unused family numbers, which were then added to the employment limits. For example, in 2021, there were approximately 140,000 unused family numbers, and those 140,000 numbers were added to the employment minimum of 140, resulting in an all-time high of approximately 280,000 numbers being available for 2022. We're coming out of COVID. State Department is getting back to essentially normal processing. So 2024 will most likely be last of the higher than minimum limits.
So a little bit closer to fiscal year 2020. And
yeah,
what are we seeing in the family-based
family
area?
based, as I said, most of the overseas posts have returned to essentially normal processing. So I think that the limits in for 2025 and on are probably going to be more in the range of the 2019 and 2020 guidelines. So the kind of splurging years, excessive amounts of numbers being available, those have passed. Unfortunately, some people got used to very fast movement of the final action dates in cases getting processed at a much faster pace during fiscal years 21, more so in 2022, and somewhat in 2023. So those expectations are not going to be reached going forward, 2024 and forward.
So you retired in fiscal year what?
At the end of, in fiscal 2022, I was retired in December of 2021.
So then that's when the highest numbers were available.
Yeah, so for the first 3 months, I was making the decisions based on that very high 280 limit for 2022.
Wow, that's great. You ended it at a high with allocating more green cards and immigrant visas. And Laura, can you tell us how is all of this impacting the corporate world, and what are you seeing?
Yeah, I mean, I think our client experience reflects, we were the busiest and filing the most adjustment of status applications in, fiscal year 2020, which then resulted in really high number of green cards being issued the next year and the following. So it was a very busy few years during COVID, despite having all the work in office restrictions. So we were seeing tons of applications getting filed, and now we're kind of coming off of that. So slower movement on filing adjustments and slower movement on green cards being issued for our clients. So reflects exactly the data here.
Okay, and let's now talk about the November Visa Bulletin. So Charlie, can you tell us, we noticed the November Visa Bulletin was published early. What do you think happened there?
I believe what the State Department did is when they established the October dates, they did so at a point that they assumed that they would hold the dates for the month of November and wait and see if their expectation based on the October dates was being realized in terms of number use. I mentioned earlier, they would have established a targeted amount so that they would want to see how those dates related to the target. It is best to hold the dates early in the year as they have done, because they can easily do so for the month of November and see where things are going. And if they have to speed up movement in order to use more numbers, they can do so because they've got another 10 months worth of demand and number use to do it. So again, so often we would hold the dates in October and November, have the same dates, and then begin to advance them for December.
Okay, and then we didn't see much movement from the October to November Visa Bulletin for the final action date. And then this, which we call Chart A, but this slide actually talks about Chart B, which is dates for filing. So can you explain what dates for filing is?
Sure. The dates for filing are established at a point where the State Department, in consultation with USCIS, feels that the final action dates will be in approximately 8 to 12 months. So when you're looking at these dates, you could assume, okay, the final action date, these should be the final action date in September in an ideal world. And what they want to do is allow applicants to use these dates for filing for adjustment of status early in the year, because they know when they are filing, it will take a considerable amount of time before the case is ready for final action. And then the State Department will notify applicants who are processing overseas and ask them to begin assembling certain required documents and submit them to the State Department, the National Visa Center, so that they can be determined whether they're ready for potential scheduling in a future month.
Okay, so Laura, what are you seeing with these dates for filing and what's been going on in our practice?
Yeah, we definitely had exciting October with some significant movement to allow many of our clients to file their adjustment of status in October. And it's a great benefit to file the adjustment of status application for our foreign national clients, given the benefits they have after filing the adjustment of status application. The benefits being an EAD as a green card applicant and advanced parole travel document as a green card applicant. So they get those roughly in 6 to 8 months of processing with the USCIS. But we saw a lot of our foreign national employees jump on it to get all their documents to us to file. And we were in a rush to file very quickly in October because we didn't want to see any retrogressions. But now that the November Visa Bulletin dates for filing was published very early, we know that if someone was delayed getting a medical exam, I know it's difficult to get appointments sometimes, they still have through November to file their adjustments. So a lot of excitement given the movement we saw from September to October, and that excitement extends through November, but there's no sort of new cases that we've pulled through November.
And Charlie, how long do you think the USCIS will allow folks to apply under the dates for filing? Because I know sometimes they'll just close it and say you have to use the final action dates.
Right. The worst case was they only early on they only allowed them to be used for October and November. In recent years, they've typically allowed them to be used until either February or March. So although I would suggest people file as quickly as possible if they are able to. Hopefully these dates will be held and allowed for use on adjustment of status filing until after the first of the year. And the State Department and USCIS will look at these dates throughout the year and determine whether they may need to be advanced or not. But for current thinking, I would just assume that these are the dates that it would apply for the year, and then be pleasantly surprised if they are moved forward.
Great. And then now it's time for your predictions for December. And so what are your predictions for December's final action dates? Because we didn't see any movement November, but will we see movement in December?
Yeah, I think that as these show, I think the EB1 for all chargeabilities will stay current, with the China moving 2 to 3 weeks, India maybe 1 to 2 months, and the other categories is listed. I think that, as I said, I had assumed that they potentially could have had some movement for November, but again, they obviously decided to hold those dates. But I think for December, they will start to move things forward. And these would be kind of averages over the course of the time. I always think it's better to be more conservative in the estimates, and then people can be pleasantly surprised if the dates were to move at a faster pace than predicted.
So when do you think the December Visa Bulletin will be published in November?
When I was chief, I would always target establishing the dates on or about the 8th of each month, and then I could forward that information for clearance through the State Department channels, and then that would allow the Visa Bulletin to be published off in normal times between the 12th and 15th of the month. Because I know that the current establishment knows that it's very important to get the information out as quickly as possible, so that practitioners and the applicants can plan for the upcoming month.
So we hear that there could be a government shutdown. So will that impact the publication of the Visa Bulletin?
I don't think so. They may hold a little bit to see if there is any congressional action, because in the Visa Bulletin, they will have an item. The shutdown has an effect on the certain religious workers in the employment fourth preference category. So they need to have an item addressing that in the Visa Bulletin. But the State Department will go ahead as normal in the establishment of the December dates. And if applicants are being processed overseas, when they're being scheduled, a note in their appointment scheduling will indicate that if there is a shutdown, there may have to be a change in the appointment.
Okay.
But
okay.
For now, for everybody, I would continue, plan to process as normal.
All right. So we'll have to see next month and see whether your predictions were accurate.
Yes.
So let's talk about estimating the minimum level of worldwide demand. And I know you've said that it's difficult because there's not a lot of data out there from the USCIS side, but can you explain this to us?
Yes, as mentioned, the USCIS does not publish information on the amount of pending demand they have in the categories that's ready to go for processing. The State Department publishes a report on an annual basis. They indicate the amount of demand on file at the National Visa Center for processing at overseas posts, and they do that as of November 1st of each fiscal year. So absent any information being publicly available, I used that November 1st, 2022 National Visa Center demand to come up some estimates on what I thought the worldwide totals of applicants that could be processed would be, resulting in these figures.
So the next one from Department of State will come out on November 1, 2023?
Well, this National Visa Center will run the report on November 1st. They will then provide it to the State Department in Washington. then that information has to be compiled and prepared in a report format. I would guess that that information will be published sometime in early to mid-December, and a notice in the Visa Bulletin announcing either the January or December dates will indicate that that information is available.
So if USCIS hasn't posted the demand data, how does this affect your predictions?
These totals are a better than nothing estimate. And so these should not be viewed as hard and fast. Again, these are based for illustrative purposes only. And so that's it. I mean, again, it would be great if USCIS and the State Department were able to publish data on a relatively real-time basis. That is not always practical.
Okay, and explaining the next slide, right? And this is the question we always get if we go to the next slide. How long will I have to wait if I filed my perm today to get a green card? And so Charlie's giving this data as not as a Department of State official, because he's retired. He's not with Department of State anymore. He's with WR Immigration. He's our director of visa consulting. And, you know, he's doing his predictions based on past number used, annual limits. And like he said before, the numbers are imperfect because we don't have complete data points. So these are just estimates, okay? And so Charlie, why don't you walk us through what your estimates are?
Right. For the employment first or employment second preference, I think a Chinese applicant filing a petition today would have a wait of approximately 5.8 years, an Indian applicant 14.7 years, and anybody else from a country, rest of world, anywhere from 2 to 3.5 years. EB3, China 4.3 years, India 7.9, and rest of world 2 to 3 years if the applicants were filing today. And the way I arrived at these figures is I made estimates of what I believe the per country limits will be in future years. And I divided that per country limit into the totals listed on the previous screen.
If we could look at the prior slide, he can explain how he arrived at these numbers.
Yeah. So what I did is on that 13,600 estimate of the amount of Chinese applicants, I made an estimate of what I think the per country limit will be for EB3 and divided that into 13,600 and came out with my year wait. Again, this is an imperfect way to do it, but absent, you know, accurate, reliable, up-to-date, complete data, it is better than nothing. But it will give people a general idea of what is probably going to be an expected wait.
Okay, so looking at this slide, you know, Laura, do you have any advice that you want to give to some of our global mobility folks about?
Yeah, I think the biggest takeaway is that the importance of initiating the green card sponsorship as early as they can in the foreign national's tenure, because establishing that priority date soonest is such a benefit to a foreign national that's going to wait at a minimum 2 to 3 years and a maximum, we said 14.7 years. And again, under the best case imperfect data that Charlie said. So quite a long time. So how important it is to initiate and establish that priority date. And the other thing is, you know, even if that foreign national employee has a priority date from a prior employer that they're porting over to the new employer, receiving a new I-140 with their current employer is important, because if there were to be any changes in the law that the foreign national could benefit, they're going to need an I-140 approval with the current employer, or there might be some significant movement forward that that foreign national would want to take advantage of. So it's always best if the company can take a look at their sponsorship policy and consider sponsorship early in that tenure. And some other things to think about is considering multiple pathways for green card sponsorship for employees. So in some instances, employees may not qualify for EB1 when they start at the employer, but because of publication, work on patents, tenure in their career, they might qualify later down the road as extraordinary ability or outstanding researcher. So taking a look at those opportunities and having a green card policy that addresses this head on, whether that's a case-by-case basis or allowing or encouraging consults for multiple pathways for green card sponsorship for foreign nationals to benefit from. And not all companies have this opportunity, but for those that do, perhaps considering retaining employees through assignment at foreign affiliates. And so the retaining here could be because an employee, foreign national, was not accepted into the H-1B lottery and is maxing out of their F1 work authorization, can leverage a foreign affiliate to park that employee there for a year. But also senior level employees, folks that are looking for managerial opportunities, and if there are business need abroad, parking a foreign national outside the US at that foreign affiliate in a managerial role to come back to the US also offers additional immigration benefits. So obviously all these strategies have to align, but considering them for foreign nationals and consulting with immigration partners to support what the impact is would be important.
So I get this question a lot. So if you do send employees out, do they still keep their place in line?
Yeah, absolutely. That priority date is that foreign nationals to port, whether they step outside the US for a short or long period, they can always come back and use the priority date. Now, of course, the immigrant visa sponsorship from that employer must be valid. So that has to be in place and valid for a foreign national to benefit from their priority date, but they don't lose it if they stay outside the US for a short or a long period.
Yeah, we've actually seen employers, they'll sponsor someone for a perm, lock in the priority date, but then, of course, it's taking so long, so these employees may change employers, but they actually do come back to the first employer who sponsored them, and that's actually quite nice because the position is pretty similar to before, and we don't have to redo the whole perm process, right? We could just go to the if the priority becomes current, we could file the adjustment of status.
Totally. I saw that a lot in 2020 and 2021.
Yes.
Folks coming back.
So they may come back. The employees may come back. And then Charlie, can you give us a walk down history and what you've seen in terms of what has happened to try and increase the annual limit or any temporary solutions that have come out of Congress?
Yeah, the last major changes to U.S. immigration policy impacting family-sponsored and employment-based number use occurred with the Immigration Act of 1990, and that took effect in fiscal year 1992. At that time, the family limit really remained unchanged from what it had been previously. And with the employment side, the employment limit went from approximately 54,000 to the current 140,000 limit. But again, nothing has really changed since that time. The next bullet says, recapturing numbers has been a solution, but any recapturing of unused numbers from earlier years can only be done through legislative action. Congress did so with the American Competitiveness Act of 2001, at which time they recaptured approximately 131,000 unused employment numbers from earlier years. Those numbers were then added to the existing limit until they were exhausted. And then in the Real ID Act of 2005, based on an extreme nursing shortage at the time, Congress felt the need to recapture numbers again and recaptured 50,000 numbers, which were made available to Schedule A workers in an effort to primarily to increase the amount of nurses which were immigrating into the U.S. to address the extreme nursing shortage that Congress was viewing at that time.
So it sounds like it's mainly, it has to be through Congress. So a lot of lobbying effort has to be invested. So if you're interested in joining some of the lobbying efforts, we invite you to contact WR Immigration, and we can assist you in that regard as well. Let's now pivot and talk about based on what we've learned today, what are some corporate green card policy benchmarking, Laura, that we can utilize? We have our rapid system where we compile a lot of data across the board. And so can you tell us what are you seeing in some of the analysis we've done with our benchmarking tools?
Yeah, so we've surveyed hundreds of corporate accounts to come up with this information to share with you all, to take a temperature of, what's out on the market, so you could bring back to your companies to check in on whether you're competitive or in the majority of what other companies sponsoring foreign nationals for green cards are doing. And the majority of companies sponsoring foreign nationals require like a 6-month tenure. Again, some more, some less, but 6 months seems to be the required tenure for companies to then approve or initiate the green card process on behalf of the foreign national. And the 6 months largely represents some sort of performance review, so that the company is making sure the foreign national is a good fit, the foreign national has had time to perform and meaningfully work with the company. This is another one that, I would tell you, I've been practicing for 10 years, and 10 years ago, I think there were fewer companies willing to support F1s or single intent non-immigrant visa holders, and that's changed. So in 10 years, we've seen the majority of companies now are sponsoring foreign nationals based on, performance review tenure, like I mentioned above, and not necessarily isolating or eliminating sponsorship opportunities for F1s, because they know the importance of a priority date. Is that the same for you, Charina? You were
Yeah.
nodding, so.
Yeah, I've been practicing for so long, and I remember my advice would always be, let's get them an H1. Like if they're on F1, let's get them an H1. But I was practicing during a time when there were unlimited H1B numbers. We never hit the cap, right? That's how old I am. We never hit the cap. But then now, it's so hard to get an H1B number, the lottery. And honestly, for as long as I practice, I've never had an issue with someone being sponsored on a single intent visa, like an F1, J1, O1E, getting a green card. And I think there's a myth out there that still is around that you have to be on an H to be sponsored for a green card, but it's not true anymore. I think you're doing a disservice to the employees, honestly, because it's going to take so long to get on an H, and then they're going to miss the boat in terms of establishing a priority date. And I think it's really important that you allow the single intent non-immigrant visa holders to also participate in green card sponsorship.
Totally.
Yeah.
And then some other high level sort of fee benchmarking is that the majority of companies are supporting fees related to the legal support and the filing fees for the adjustment of status application for both the employee being the principal applicant as well as their dependents. So the majority are supporting that. And we brought this up at a conference recently, and I saw a lot of heads nodding, but there were some differing opinions. Most companies that I work with are not doing reimbursement agreements, although some still are. So it's still split. The reimbursement agreement meaning, does the company have the foreign national sign some sort of agreement that if they depart the company within a stated time frame, the company recoups some of the eligible legal or filing fees that the company spent on behalf of the foreign national. In the room or at the conference, folks were sort of saying, like, of those that have the reimbursement agreements, many are not enforcing them. So it's really more the reimbursement agreements are being used to facilitate a conversation with the foreign national about the benefits and the timeline and the efforts involved. Supporting medical exam fees, I've heard these have gone up in the last few years, so
Yeah.
they can be quite expensive. Still a minority of companies, their minority of companies are supporting this. So the majority are not supporting the medical exam fees for foreign nationals, employees that need them for the adjustment of status applications.
So one little tip that I always give my clients, because it's not covered by insurance, right? But you
Oh,
could
sure.
actually go to your primary care advisor or the doctor and ask them to just double check if all your vaccinations are up to date. And I think your insurance will actually cover getting you up to date in vaccinations. So when you go to the USCIS approved provider, maybe you don't have to pay as many lab fees, you know,
Oh, good point.
because insurance has covered it. So that's my little tip for the day.
Love that. And then finally, from the support multiple preference categories, this was a recommendation we spoke about a little bit earlier here in light of Charlie's predictions. This is more dealt with on a case-by-case basis for employers. So there's few out there that are sort of saying, we always do or we always don't. This is often referred to as like a case-by-case that companies are willing to like look into it on the individual level.
Okay. And what are some of the best practices you're seeing?
Well, we're definitely resounding feedback, and all of you on the call probably are aware that the employers are sponsoring foreign nationals to attract and retain top talent, and that the green card sponsorship is no longer a perk for maintaining or retaining top talent, but it's mandatory. So there's no company out there that is sponsoring H-1Bs anymore and not sponsoring a green card. So the majority are going all the way through with this to make sure they can retain that talent. The best practice here is a written policy. I still support clients all the time that don't have a policy. They just sort of say like, oh, what did we do last time? And sort of build it on sort of precedent. But the best practice is to have a policy to ensure things are handled consistently and fairly. And that, you know, on that point, there's always exceptions to the rule about how soon you're going to start green card processing, because there might be a business exception, or whether you're going to cover visa fees because the employee needs to travel during the course of business. But what we want to make sure you have, and the best practice here, is a process. So the company has a process for handling exceptions. So whether that's multiple authorizations, or at what level you're handling those authorizations or approvals for the exceptions, sort of having a documented process for that to ensure that those exceptions are dealt with on a fair and consistent basis. The other best practice recommendation we're making here is to address immigration budget at regular intervals. So we know and have been expecting USCIS to increase filing fees for some time now. And so working with your immigration counsel to project fiscal year fees for the upcoming year. You could do that on a quarterly basis, on a yearly basis, to make sure everybody's aware of just how much the program spend is, and that you're making targets or where you are on those targets in light of potential fee increases.
Yeah, with our rapid tool, we can actually do quarterly business reviews, right? That clients have found to be really, really helpful as they're trying to explain to C-suite or whoever, why the immigration spend has been so high, right? And what it's looking like in terms of how long it takes to get a green card, how many times do we have to extend somebody. So data really is important to be able to come up with the best practices for your program.
Absolutely. We also want to make sure our companies and clients are discussing sponsorships with candidates upfront to manage expectations. So if you're a company that has a 1-year tenure before sponsoring green card, making sure that that candidate knows upfront. You just have a better experience overall if they know what to expect, rather than 3 months in saying, okay, I'd like to get started, and you're like, wait, no one talked to you about this. It can put the manager or the company HR in a really awkward position. And that, of course, we want to make sure everybody's regularly engaging with their foreign national employee population to make sure documents remain valid. I had a client whose passport expired. And so like those sort of very basic things still need reminders, need engagement to make sure folks are having all of their documents in order. Because what if you could file your green card in the next month? You want to make sure all the documents are ready and available to facilitate a quick filing. And that also includes compliance check-ins. When you're engaging with the foreign national employee population, not only are you making sure they're in valid work authorized status, but you also want to make sure that they're compliant with that status and are in the locations that their H-1B petitions state that they are there.
Yes, because you don't want to have to redo the perm process, right? So it's important you check in and know exactly what you have to handle in case there are changes with employment. So we have some time to go through some of the questions that have come in. So Laura,
we've got a lot.
I know I saw there's quite a number of questions that have come in.
Okay, I'll try to tack through them.
Yeah.
Tack through them.
Okay.
So Charlie, this one's for Charlie. Do you see priority date in the EB2 or EB3 India category? Do you see like priority date 2012 will be covered, will become current for final action in fiscal year 2024?
Both
I think
for
that's the
India,
question.
yeah, but the current India application filing date for India second preference is May 15th of 2012. In India third, the filing date is August 1st of 2012. In theory, that is where the final action dates will reach no later than September. But again, there's no guarantee. That is just where the State Department has estimated that final action dates are likely to be.
Got it. This is a nice question. Can you explain this again for Charlie? Can you explain what is meant by the monthly demand usage as a guide? Adjust the dates. If according to both Department of State and USCIS already have enough application for most categories from previous years.
Right. And I saw one of the other questions was a question about what are the quarterly limits.
Yeah, that's the next one.
So I'll kind of combine that into one answer.
Awesome.
Using the estimate of 160,000 as the annual limit for employment, the quarterly limits during each of the first 3 quarters are 27% of the overall limit. That would be 43,200 numbers that could be used in theory during the period October through November, or October through December, January through March, and April through June. That results in using approximately 14,400 numbers per month. So when State Department determines the October and November and December dates, their goal is to try to be using in each of those months 14,400 numbers. If they see that they have used more than that amount, then they may try to hold the dates for a period of time so that over the course of the quarter or the first 6 months or the first 9 months that they bring number use within those 27% quarterly limits. So it's entirely possible that they could, instead of using 43,200 for October through December, that they could use 55,000 or 60,000 numbers. Then all they would do is maybe slow down number use so that total number use through March would be at 86,400. But again, they could adjust their monthly number use targets to kind of come in line with those quarterly limits.
Nice.
And one of the things, the goal of those limits, the reason they're higher is that allows most of the numbers, a higher percentage, 81% of the numbers to be used in the first 9 months. and then there's only 19% of the limit used for July through September, that kind of lets you ease into the annual limits. Instead of keeping your foot on the gas pedal all the way up to the traffic light, you can start easing off as you approach the light 100 yards back and kind of ease into the light so you don't have to slam on the brakes at the last second.
So is that why, Charlie, we see retrogression starting usually around the second quarter?
It can be, because what they would do is, you know, if, as I said, if you saw that you were at, say, 50 or 60,000 numbers for the first quarter, you could say, okay, I'm going to hold the dates for, you know, the coming months, so that by the end of March, I will be at the appropriate 86,400 target for the first 6 months. If you saw that at that point you were at 100,000, you'd say, okay, I can't take a chance on, you know, number use declining to bring me back into the limit. I'm going to have to retrogress the dates for April or May or June to get things back under control, because if I don't, then we're going to have extreme retrogressions later in the year or potential unavailability of numbers.
So before, you said the USCIS, sometimes you don't really get the numbers until later, right? So could that shift your quarterly, your monthly allocation as well?
Yeah, because this in State Department and USCIS would be consulting, because USCIS uses at least 85% of the employment numbers. So state has to rely heavily on USCIS estimates. If those estimates were made in good faith and they prove to be inaccurate, either higher or lower, then they would have to take the corrective action one way or the other in the future. And a lot of times the immigration's estimates can be, you know, based on historical patterns, and suddenly something strange happens. Either far fewer applicants are suddenly filing, or far more than they expected are filing. So it's kind of an inexact science. But again, that's why I believe that State Department held the dates for November, so that they could kind of get an idea where things are going. And it's even possible they might decide we're going to go ahead and hold them again for December, just so we get a good idea of where things are going, because we know that we have another 9 months to catch up and get where we want to be, and not have the amount of retrogressions that we've been seeing in recent years.
Okay. We have one.
We don't have time.
Yeah, we're at time, but maybe we could just take one more question, Laura.
Okay, this one's for you. Who gets a combo card, meaning advanced parole EAD, versus who gets a standalone EAD and a standalone AP, advanced parole?
That's a good question. What we've been seeing is they stopped doing the combo card because they were focusing all their resources on doing mainly the EAD. But then now they have a new rule, right? Or new policy, right, Laura, that they're issuing, is it EAD and AP for 5 years now?
Yeah.
Like after after September, I can't remember the date. But yeah, it's hard to say, but I think with this new practice, if your case was filed before that cutoff, you may see a single like EAD or AP card. But after the policy change, you should see a combo card, right, Laura, for 5 years?
Yeah, so you might not have gotten it on the last extension, but a huge improvement, because it felt like you were always every 6 months filing them. I think that brings us to time.
Yeah, that brings us to time. We're having our next one in November. We're gonna try and shoot for right before the Thanksgiving holidays. So hopefully the Visa Bulletin comes out by the time we want to do our webinar. If it doesn't, we'll have to see if we have to move the date. But wanted to thank everyone again for joining. I know there were a lot of questions. We'll try and answer them in the next session as well too. But Laura and Charlie, thank you again for joining me, and hope everyone has a wonderful day.
Likewise. Thank you.
Take care.